Sometimes the biggest, most complicated stories start out really small. A simple neighborhood disagreement, maybe a tense email. And then, before you know it, it's somehow become a federal case. Today, we're going to unpack exactly how something like that can happen. We're going to look at the actual documents that tell the story of one resident versus her homeowners association. So let's start with who's involved. So the official case is Michele Beauchamp versus the villages at Rio Paseo Condominium Association. I mean, when you see the names laid out like this on what's essentially a legal document, it becomes crystal clear. This isn't just a friendly chat over the fence anymore. Oh, no. This is a full-blown legal battle. And that really brings us to the big question we're tackling here. How does a conflict over someone's behavior in an online meeting spiral so far out of control that lawyers and judges have to get involved? To figure that out, we're just going to follow the evidence piece by piece. Now, to really understand what's at stake, we're going to do something a little different. We're actually going to start at the end of the story. Yeah, this first document we're looking at shows us just how serious things have gotten. And here it is, an official order from the Office of Administrative Hearings, dated August 2nd, 2024. It says the case is being ordered into mediation. So, what does that even mean? It means this whole dispute has gone way beyond informal complaints. It is now deep in a formal legal process that needs a neutral third party to step in and try to help sort it all out. Okay, so how on earth did we get to the point of legal mediation? For that, we gotta hop in the time machine and go back almost 4 years, all the way to December of 2020. And it all kicks off, as these things so often do, with a single email. This is the very first line of an email from the HOA president to Michele Beauchamp, who, by the way, was actually a board member herself at the time. Right from the jump, you can tell the tone is super official, super serious. The HOA is basically putting one of its own on notice. And the email gets really specific, listing out all these alleged violations from a Zoom meeting. Things like muting her audio to talk to other people, texting, even missing a really important vote. Plus interrupting others and using a condescending tone. From the HOA's perspective, this was totally unprofessional and a clear violation of their code of conduct. And then we get to the line that just changes everything. The email ends with a direct threat. It says, and I'm quoting here, "The board of directors will begin levying fines against you." Wow. This is what takes it from a simple warning about behavior to a serious financial threat. So far it seems kind of straightforward, right? A board member was acting unprofessionally. But hold on, because a completely different document from just 1 month before that meeting, well, it adds a whole new, really important layer to this story. Check this out. It's a plumbing invoice from November 11th, 2020. And the description is pretty blunt. It's for a sewage backup. This tells us that in the weeks right before that heated meeting, this resident was dealing with a massive, messy, and I'm sure incredibly stressful problem inside her home. And these photos, they show you the reality of what that invoice means. On the left, a perfectly normal kitchen. On the right, floors that are visibly stained and ruined by water damage. Now, just imagine trying to live your life, let alone manage your volunteer duties for the HOA, while your home is literally falling apart. It paints a totally different picture of her state of mind during that meeting, doesn't it? And this is the exact point where the story pivots from a neighborhood tiff to a potential federal case, because the whole context of what was happening in her home brings a really powerful piece of federal law into play, the Fair Housing Act. At the heart of the Fair Housing Act is this concept called reasonable accommodation. So what on earth is that? Well, as you can see here, it's basically a change or an exception to a rule that might be necessary for someone with a disability to have an equal shot at using and enjoying their home. The key here is that it's not about getting special treatment, it's about getting fair and equal access. So this is it. This is the core conflict laid out right next to each other. You have two totally different ways of seeing the exact same events. The HOA saw unprofessional behavior that broke their rules. Simple as that. But if you look at it through the lens of the Fair Housing Act, you might see a resident in deep distress, dealing with a crisis that could have triggered or made a disability worse. And from that perspective, she might have needed an accommodation, some flexibility, not a fine. So, where does all this leave us? We've basically followed the breadcrumbs from a sewage backup and a tense Zoom call all the way to two completely different legal interpretations of what happened. Let's connect the dots on a timeline. Okay, this timeline really puts it all together. November 2020, the messy sewage backup. 1 month later, December 14th, the infamous Zoom meeting that led to that warning email. And get this, the very next day, December 15th, the board formally votes to adopt the same code of conduct they just used to warn her. Then you fast forward nearly 4 years, and bam, August 2024, the whole thing lands in formal legal mediation. And that leaves us with the million-dollar question. These documents tell two completely different stories. So, what was this? Was it a clear-cut case of an unprofessional board member just being disruptive? Or was it a housing association that failed to see a resident in crisis? And by doing that, maybe failed in its legal duty to provide a reasonable accommodation? Well, the answer to that is now up to the mediators and maybe even a judge to decide.